Picture a Roman woman in 45 CE sitting in her tablinum, calmly writing a brief message, "Take your things and go," that will end her 10-year marriage by the time her messenger delivers it that afternoon. No lawyers, no judges, no hearings required, just a simple declaration that Roman law would immediately recognize. So sit back, grab a cup of tea, and get ready to explore how Romans could end marriages with a simple written notice sent to their spouse. Discover why no courts, lawyers, or judges were required for divorce. Understand how either husband or wife could unilaterally terminate marriage, and learn what Roman divorce freedom, dowry returns, remarriage patterns, and how Christianity would later make this simple process nearly impossible, reveals about changing attitudes toward marriage, women's autonomy, and the legal revolution that transformed personal relationships. In ancient Rome, marriage was a private contract between families, not a sacrament ordained by gods or state. It followed naturally that ending such contracts required no divine permission or government approval. The legal formula was breathtakingly simple. One spouse had to communicate to the other their intention to end the marriage. That communication, called repudium, literally rejection or refusal, could be delivered verbally, in writing, or through a messenger. Once delivered, the marriage was over. Immediately. No waiting periods, no contested proceedings, no judge to convince what took a moment to say, could take a generation to recover from emotionally and financially. But legally, divorce was instantaneous. The most formal version of repudium used the phrase tuus res tibi habeto, take your things for yourself, return to your own affairs. These words, witnessed by 7 Roman citizens, constituted an official divorce that couldn't be disputed. But such formality was optional, not required. A wife could simply leave her husband's house and return to her family, declaring the marriage over. A husband could expel his wife with a verbal command. The lack of mandatory procedure meant divorce could be as simple or as complex as circumstances demanded. This simplicity seems shocking to modern observers, raised in cultures where divorce requires legal proceedings, division hearings, custody battles, and often years of process. Yet Roman law's approach had its own logic. If marriage was a private contract requiring only mutual consent to form, why should its dissolution require government intervention? The state's interest lay in protecting property rights and ensuring children's welfare, not in forcing couples to remain together. Roman pragmatism valued clear rules over moral enforcement. The crucial detail that made simple divorce workable was the dowry system. When a Roman woman married, her family provided a dowry, property, money, or goods, that became part of the marital estate but remained legally hers. Upon divorce, the dowry had to be returned to the wife or her family. This requirement wasn't optional. Dowry return was mandatory under Roman law, with specific time limits and penalties for non-compliance. A husband who couldn't or wouldn't return the dowry faced legal action that could result in property seizure and public shame. The dowry return requirement served multiple functions. It protected women's economic interests, ensuring they didn't face destitution after divorce. It deterred frivolous divorces by making them costly for husbands. Returning the dowry meant surrendering significant assets. It also protected women's birth families, who regained the dowry if marriage dissolved, allowing them to arrange new matches. The system wasn't perfect protection, but it was far more than women in many other ancient societies possessed. Calculating dowry returns could be complex. If the dowry included property that had been sold or developed, equivalent value had to be returned. If it included slaves who had died or businesses that had failed, compensation was required. Interest might be owed if return was delayed beyond statutory limits. Disputes over dowry valuation often required lawyers, despite divorce itself requiring none. This created the odd situation where divorce was legally simple but financially complicated, particularly for wealthy Romans with complex estates. The question of children cut to the heart of Roman patriarchal structure. Under Roman law, children belonged absolutely to their father through patria potestas, paternal power. Upon divorce, children stayed with the father regardless of who initiated the divorce or what had caused it. Mothers had no automatic custody rights. This harsh reality meant women divorcing faced losing daily contact with their children, seeing them only if ex-husbands permitted. Yet reality was more nuanced than legal theory. Social pressure often led fathers to allow mothers substantial access to children. Remarried women sometimes negotiated bringing children to new households. Grandparents might mediate, ensuring mothers maintained relationships with grandchildren. For young children, especially infants still nursing, fathers often allowed them to remain with mothers until weaning. The law gave fathers absolute power, but social custom and practical necessity moderated that power's exercise. Either spouse could initiate divorce, a feature that distinguished Roman law from most ancient legal systems. Women's ability to divorce was particularly unusual. In most ancient cultures, men could divorce wives relatively easily while women faced impossible barriers. Roman women, at least legally, possessed equal divorce rights. They could leave marriages that were abusive, loveless, or simply inconvenient. This legal equality didn't guarantee social equality. Women who divorced faced harsher judgment than men, but it provided options unavailable elsewhere. The actual exercise of divorce rights varied dramatically by social class. Elite women with powerful families backing them could divorce with relative impunity. Their birth families wanted them back if marriages proved unsatisfactory, ready to arrange more advantageous matches. Lower-class women faced practical barriers. Where would they go? How would they support themselves? Without powerful family backing, women's theoretical divorce rights might be meaningless. The law permitted what economics and social reality often prevented. Elite divorce patterns reveal political and social dynamics. Aristocratic Romans married for political alliance, not love. When alliances shifted, marriages dissolved. Some Romans divorced and remarried multiple times, each marriage serving different strategic purposes. Sulla married 5 times. Pompey married 5 times, Julius Caesar 3 times. These serial marriages weren't scandals but strategic calculations, marriage as diplomatic tool rather than lifelong commitment. The speed of remarriage could be startling. Women were supposed to wait 10 months before remarrying to avoid paternity confusion, but men faced no such restriction. A divorced man might remarry within weeks or even days, sometimes to a woman already chosen before divorcing his previous wife. Women, once the waiting period expired, also remarried quickly. The marriage market for divorced women of good family could be quite active, especially if they brought substantial dowries back from their previous marriages. Social attitudes toward divorce were complex and contradictory. Romans simultaneously accepted divorce as normal and gossiped scandalously about specific instances. Frequency didn't eliminate judgment. A woman who divorced was exercising legal rights, but also providing material for social commentary. The grounds for divorce, even if legally irrelevant, mattered socially. Divorcing an abusive drunk earned sympathy. Divorcing a loyal provider for a wealthier prospect invited criticism. The law might not care about reasons, but society certainly did. Philosophers and moralists regularly condemned easy divorce as symptom of declining values. Seneca complained about women who measured years by their husbands, divorcing and remarrying so frequently they'd had 5 husbands in 5 years. Juvenal's satires mock serial marriage as moral decay. These complaints suggest tension between legal permissiveness and traditional values that prized marital stability, but complaints didn't change law or practice. Romans continued divorcing easily while publicly lamenting the moral implications. Augustus attempted to address what he saw as excessive divorce through the Lex Julia de Maritandis Ordinibus, part of his broader marriage legislation. He didn't prohibit divorce. That would have been too radical, but tried to discourage it through incentives for stable marriage and penalties for remaining unmarried after divorce. The law exempted men from certain obligations if they stayed married, offered political advantages for fathers of multiple children, and imposed disadvantages on the divorced and unmarried. These measures had limited effect, showing how difficult legislating private behavior can be. The procedures for divorce, while legally simple, were often socially elaborate. Elite families might negotiate settlements over weeks or months, despite the legal divorce being instantaneous. Lawyers worked out property divisions, future obligations, and arrangements for children. Public announcements sometimes declared divorces, clarifying relationship status for political and social purposes. What took a moment legally might take months practically, especially when complex estates and powerful families were involved. Documentation practices varied by class and circumstance. Wealthy Romans often created detailed divorce records, listing returned property, financial settlements, and custody arrangements. These documents weren't legally required, but served practical purposes in preventing future disputes. Poorer Romans might simply inform witnesses that divorce had occurred, relying on memory and reputation rather than written records. The Papyri from Roman Egypt preserve numerous divorce documents, showing the range from elaborate contracts to simple declarations. The gendered experience of divorce differed significantly despite legal equality. Men faced fewer social consequences and no custody loss. They typically initiated divorce more frequently and suffered less economic impact. Women, even when legally empowered to divorce, navigated social judgment, potential custody loss, and economic uncertainty. A wealthy woman with family support might thrive after divorce. A poor woman without resources might face destitution. The law treated men and women equally. Society and economics did not. Remarriage strategies reveal how Romans understood marriage. For many elite men, marriage was portfolio management, assembling alliances, consolidating property, producing heirs. Divorce and remarriage allowed adjusting this portfolio as circumstances changed. For women, remarriage offered economic security and social positioning, but required careful timing and selection. Widows often had more advantageous positions than divorces, as death ended marriage without scandal, but both faced active remarriage markets. The question of love in Roman marriage deserves consideration. Did Romans divorce so easily because they didn't love their spouses? The evidence suggests Romans felt all the emotions we associate with marriage: affection, passion, jealousy, heartbreak. Tombstone inscriptions celebrate loving marriages that lasted decades. Letters between spouses reveal genuine emotional bonds. But Romans separated emotional attachment from legal structure. You could love your spouse deeply while recognizing marriage as a legal contract terminable by either party. The modern conflation of romantic love with marriage's legal structure would have seemed strange to them. Children caught in divorces faced difficult situations despite legal certainty that they belonged to fathers. Emotional bonds with mothers remained even if legal custody didn't. Some children, especially older ones, might voice preferences that fathers considered. Property settlements sometimes included provisions for children's care, though these couldn't override paternal rights. Maternal grandparents might negotiate access. The law was clear, but human relationships created complexities law couldn't fully address. Slaves presented a special case. They couldn't legally marry in Roman law, so they couldn't legally divorce. Yet slaves formed partnerships Romans called contubernium, living as couples and raising children. When these partnerships dissolved, through sale separating partners, death, or mutual separation, no legal process existed. Slaves' personal relationships existed outside legal recognition, making their divorces simultaneously simpler, no legal procedure, and more precarious, no legal protections. Christianity's triumph transformed Roman divorce law radically and permanently. Church fathers opposed easy divorce. Citing Jesus' teachings on marriage's permanence, Augustine argued that marriage created a mystical bond that humans couldn't sever. Christian emperors, beginning with Constantine, gradually restricted divorce. First, they required cause: adultery, serious crimes, life threats. Later, they reduced acceptable causes further. Eventually, divorce became practically impossible for Christians, a complete reversal of earlier Roman practice. The transition wasn't immediate or complete. Old attitudes persisted alongside new theology. Some Christians continued divorcing by traditional methods while seeking church sanction, others formally separated without legal divorce, navigating between Roman law and Christian theology. The legal restrictions took centuries to fully implement, showing how resistant personal behavior is to legislative change, even when backed by religious authority. What was lost in this transformation deserves recognition. Roman divorce law, for all its problems, granted women autonomy unusual in the ancient world, the right to leave an unhappy or dangerous marriage, to escape abusive partners, to choose new paths. These weren't trivial freedoms. When Christianity made divorce nearly impossible, women lost options their pagan grandmothers had possessed. The gain in marriage stability came at the cost of individual choice, a trade-off whose wisdom remains debated. Modern divorce law in Western nations owes surprisingly little to Roman precedents. The medieval church's restrictions so thoroughly overwrote Roman practice that when modern no-fault divorce emerged in the 20th century, it wasn't recovering Roman law but independently arriving at similar conclusions. Yet the Roman example shows that easy divorce isn't modern invention or social decay, but a legal approach that one of history's most successful civilizations adopted and maintained for centuries. Comparing Roman divorce with modern practices reveals interesting parallels and differences. Both systems recognize that forcing couples to remain married serves no one's interests. Both attempt to protect economic interests and children's welfare. Roman dowry returns parallel modern property divisions. Roman paternal custody mirrors some modern presumptions, though we've moved toward considering children's best interests rather than fathers' rights. The mechanisms differ, but underlying recognitions that marriages end, that divorce needs legal frameworks, that economic and custody issues require resolution, remain constant. The story of Roman divorce ultimately reveals a civilization that valued practical solutions over moral absolutism in private matters. They recognized that marriages could fail, that forcing people to stay married created misery without benefit, and that legal clarity about divorce served social stability better than pretending it didn't happen. This pragmatic approach characterized Roman law generally, contributing to its longevity and influence. As you finish your tea and reflect on this surprisingly modern aspect of ancient Rome, consider what it tells us about the relationship between law, morality, and social change. Romans permitted what many later societies forbade. They saw marriage as dissolvable contract. Others saw it as sacred bond. Neither view is objectively right. Both reflect different values about marriage's nature and purpose. Understanding Roman divorce helps us see our own divorce laws in historical context, recognizing that current practices aren't natural or inevitable, but choices shaped by particular cultural and religious values. The simple notice that could end a Roman marriage, take your things and go, carried within it a philosophy of relationships, property, and personal autonomy. It recognized that human bonds can break, that legal compulsion can't create emotional connection, and that clear rules about dissolution serve everyone better than forcing permanence. Modern divorce law, though far more complex in procedure, often aims at similar goals. The specifics changed across 2,000 years, but the recognition that marriages sometimes end and that law should manage that ending fairly connects us across the centuries to those Romans who wrote divorce notices without requiring judges to approve them.